After studying this module, you shall be able to know about the significance of obscenity and pornography, the contemporary statutes in India related to obscenity and pornography, and various sanctions provided under the special laws. Freedom of expression is a fundamental human right, both in itself and due to the role it plays in ensuring other rights. At the same time, law permits for limited constraints on it to protect other significant social interests such as confidentiality, individual reputation, and public order. It is certainly not easy to strike an appropriate equilibrium between these other interests and freedom of expression. A perfect example is modernization and obscenity, but the concept of obscenity is way too complicated. It is not that much easy to calculate the degrees of an obscene conduct, or rather a conduct. An act which may be normal for a particular individual, community, or area may not be deemed appropriate to another one. For one individual, it may be a piece of art, while for others, it may be a nasty activity. For example, a commercial on a condom in a national television channel may be supposed by some audience as an offensive or obscene program, while some audience may take it as a requirement of present time. Honorable Supreme Court has observed in Ranjit D. Udeshi versus State of Maharashtra, All India Reporter 1965, Supreme Court 881, that the test of obscenity to adopt in India is where an obscenity is published with a commercial purpose and no other social purpose. It cannot have the constitutional protection of free speech and expression. Treating sex in a manner appealing or having the tendency to appeal to the cardinal desire of human nature is definitely obscenity. If obscenity is overlooked for a while, pornography is legal in many countries, but on the other hand, it is also severely prohibited in many other countries. There is no established definition of pornography or obscenity. A common understanding of the term obscenity would indicate the violation of prevalent moral codes in words, representations, or actions that are available to the public at large. It is basically associated with matters that contain sexually explicit material. Pornography can be understood as sexually explicit representation which has the purpose or intention of sexually arousing its audience. Besides, pedophilic psychology has cursed the human society and modified the conventional pornography to the most displeasing, disinclined involvement of children in form of child pornography. The term child pornography implies conventional pornography with child subjects. The term is retained because it is the expression most voluntarily recognized by the public on the whole. Pedophiles who exchange child pornographies via computer are actively using encryption. Criminal organizations seem to be using the proceeds of IP infringing products to facilitate pornography. Pornographic sites open the syndicate to legal accountability by not preventing the access of such material because the technology exists. Now, next is obscenity and pornography in the digital world. Although the Indian Constitution guarantees the fundamental right of freedom of speech and expression, it has been believed that a law against obscenity is legitimate. The Supreme Court has defined obscene as offensive to modesty or decency, lewd, filthy, repulsive. Section 67 of the Information and Technology Act is the most severe Indian law punishing cyber pornography. Other Indian laws that deal with pornography contain the Indecent Representation of Women, Prohibition Act, and the Indian Penal Code. Anyhow, if obscenity is discussed, it will reason an extensive debate about the degree of an act which affirms the criteria of obscenity. Electronic media and print media are two main sources from where a base of obscenity may upsurge. To understand what constitutes obscenity or pornography in the electronic or digital form, it is necessary to understand about the available medias in the society and to its users. Any material in the context would consist of video films, audio films, text files, images, animations, etc., which may be stored on CDs, websites, computers, cell phones, etc. The internet, while encouraging knowledge-based industries and commerce, also makes it easier to steal, produce and distribute merchandise such as software, music, films, books and games. With the click of a mouse, identical copies can be reproduced and transferred instantaneously, economically, clandestinely and repetitively. The internet has augmented the range, volume and accessibility of sexually abusive images, including pornography. Pornography is sarcastically believed to be the first constantly popular e-commerce product by deceptive marketing maneuvers and mouse-trapping technologies. Pornography encourages consumers to access their websites. Anybody as well as children can log on to the internet and access websites with pornographic matters with a click of a mouse. Pornography on the internet is available in different formats. This ranges from pictures and short animated movies to sound files and stories. The internet also makes it possible to discuss sex, watch live sex acts and arrange sexual activities from computer screens. There have been countless attempts to limit the accessibility of pornographic content on the internet by governments and law administration bodies all around the world, but with little effect. Now we shall see the legal provisions related to obscenity and pornography. As discussed earlier, there are several countries where pornography is prohibited and obscenity with a certain amount is dealt accordingly. Indian law also publishes stringent legal constraint upon such activities. Apart from Indian Penal Code, the Information and Technology Act and the Indecent Representation of Women Prohibition Act has imparted certain statutes that contravention of these laws may result severe consequences. First, we shall discuss about the Indian Penal Code 1860, Section 292, sale etc. of obscene books etc. First, for the purpose of subsection 2, a book, pamphlet, paper, writing, drawing, painting, representation, figure or any other object shall be deemed to be obscene if it is lascivious or appeals to the pertinent interest or if its effect or where it comprises two or more distinct items. The effect of any one of its items is, if taken as a whole, such as to tend to deprave and corrupt a person, who are likely, having regard to all relevant circumstances, to read, see or hear the matter contained or embodied in it. 2. Whoever a. sells, lets to hire, distributes, publicly exhibits or in any manner puts into circulation or for purposes of sale, hire, distribution, public exhibition or circulation makes, produces or has in his possession any obscene book, pamphlet, paper, drawing, painting, representation or figure or any other obscene object whatsoever, or b. imports, exports or conveys any obscene object for any of the purposes aforesaid, or knowing or having reason to believe that such object will be sold, let to hire, distributed or publicly exhibited or in any manner put into circulation, or c. takes part in or receives profits from any business in the course of which he knows or has reason to believe that any such obscene objects are for any of the purposes aforesaid made, produced, purchased, kept, imported, exported, conveyed, publicly exhibited or in any manner put into circulation, or advertises or makes known by any means whatsoever that any person is engaged or is ready to engage in any act which is an offence under this section, or that any such obscene object can be procured from or through any person, Or E. Offers or attempts to do any act which is an offence under this section shall be punished on first conviction with imprisonment of either description for a term which may extend to 2 years and with fine which may extend to 2,000 rupees, and in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 5 years and also with a fine which may extend to 5,000 rupees. Now there are certain exceptions to this section. Exception: this section does not extend to A. Any book, pamphlet, paper, writing, drawing, painting, representation or figure, the publication of which is proved to be justified as being for the public good on the ground that such book, pamphlet, paper, writing, drawing, painting, representation or figure is in the interest of science, literature, art of learning or the other objects of general concern, or which is kept or used bona fide for religious purposes. B. Any representation, sculptured, engraved, painted or otherwise represented on or in first an ancient monument within the meaning of the Ancient Monuments and Archaeological Sites and Remains Act of 1958, or any temple or any car used for the conveyance of idols or kept or used for any religious purposes. Next is section 293, sale etc. of obscene objects to young person. Whoever sells, lets to hire, distributes, exhibits or circulates to any person under the age of 20 years any such obscene object as is referred to in the last preceding section or offers or attempts so to do shall be punished on first conviction with imprisonment of either description for a term which may extend to 3 years and with fine which may extend to 2,000 rupees, and in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 5,000 rupees. Next is section 294, obscene acts and songs. Whoever to the annoyance of others does any obscene act in any public place or sings, recites or utters any obscene song, ballad or words in or near any public place shall be punished with imprisonment of either description for a term which may extend to 3 months or with fine or with the both. Next is the Indecent Representation of Women Prohibition Act of 1986. The Indecent Representation of Women Prohibition Act of 1986 was enacted to prohibit indecent representation of women through advertisements or in publications, writings, paintings, figures or in any other manner. The Act, however, in its present form relates primarily to the print media. Since the enactment of the Act, technological revolution has resulted in development of new forms of communication such as internet and satellite-based communication, multimedia messaging, cable television, etc. It has thus become imperative to widen the scope of the law so as to cover such forms of media on one hand and to strengthen the existing safeguards to prevent indecent representation of women through any media on the other. Section 3. Prohibition of advertisements containing indecent representation of women. No person shall punish or cause to be punished or arrange or take part in the publication or exhibition of any advertisement which contains indecent representation of women in any form. Next is section 4, prohibition of publication or sending by post of books, pamphlets, etc. containing indecent representation of women. No person shall produce or cause to be produced, sell, let to hire, distribute, circulate or send by post any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation or figure which contains indecent representation of women in any form. provided that nothing in this section shall apply to A. Any book, pamphlet, paper, slide, film, writing, drawing, painting, photograph, representation or figure. First, the publication of which is provided to be justified as being for the public good on the ground that such book, pamphlet, paper, slide, film, writing, drawing, painting, photography, representation or figure is in the interest of science, literature, art or learning or other objects of general concern. The Information and Technology Act 2000, Section 67, Publishing of information which is obscene in electronic form. Whoever publishes or transmits or causes to be published in the electronic form any material which is lascivious or appeals to the prurient interest, or if its effect is such as to tend to deprave and corrupt persons who are likely, having regard to all relevant circumstances, or to read, see or hear the matter contained or embodied in it, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 1 lakh rupees. And in the event of a second or subsequent conviction with imprisonment of either description for a term which may extend to 10 years and also with fine which may extend to 2 lakh rupees. This section explains what is considered to be obscene and also lists the acts in relation to such obscenity that are illegal. After the Information and Technology Amendment Bill of 2008 was enacted, 2 more sections related to such activities were inserted in the Principal Act. They are Section 67A, Punishment for publishing or transmitting of material containing sexually explicit act, etc. in electronic form. Whoever publishes or transmits or causes to be published or transmitted in the electronic form any material which contains sexually explicit act or conduct shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees. And in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 10 lakh rupees. Next is Section 67B, Punishment for publishing or transmitting of material depicting children in sexually explicit act, etc. in electronic form. Whoever publishes or transmits or causes to be published or transmitted material in any electronic form which depicts children engaged in sexually explicit act or conduct, or creates text or digital images, collects, seeks, browses, downloads, advertises, promotes, exchanges or distributes material in any electronic form depicting children in obscene or indecent or sexually explicit material, or cultivates, entices or induces children to online relationship with one or more children for and on sexually explicit act or in a manner that may offend a reasonable adult on the computer resource, or facilitates abusing children online, or records in any electronic form own abuse or that of others pertaining to sexually explicit act with children, shall be punished on first conviction with imprisonment of either description for a term which may extend to 5 years and with fine which may extend to 10 lakh rupees, and in the event of second or subsequent conviction with imprisonment of either description for a term which may extend to 7 years and also with fine which may extend to 10 lakh rupees. Thus, with the insertion of Section 67B for the first time, child pornography was dealt with a separate and dedicated statute. We shall end this module with the summary. Obscenity is something which is not acceptable to the human perception by and large due to its immoral, philistine, indecent form. Obscenity is no way restricted only up to the visual opinion, but it can be something which is not suitable to be heard. Theory of obscenity depends upon the surroundings of individual getting its exposure. For instance, a painting portraying nudity made by a renowned artist may be appreciated by the similar set of people, but may be cherished by others as they may find it obscene. The wider broadcast mediums of obscenity are unfortunately the electronic media. Since internet, television and other medias are easily in the reach of every person, it has poignantly spread obscenity in many ways. Pornography is the depiction of acts done in the course of sexual intimate movements. While pornography is legal in many countries, it is strictly prohibited in several other countries including India, and the same is penalized under the statutory laws. Most of the pornographic websites are hosted from the servers located outside the country to avoid any legal restrictions. Sections 292, 293 and 294 of the Indian Penal Code, Sections 3 and 4 of the Indecent Representation of Women Prohibition Act, and Section 67 of the Information and Technology Act 2000 deals with the obscenity and pornography as the case may be.